Good morning, Your Honors. I'm James M. Crane of the Knox County Bar, appointed to represent Mr.
Mr. Crane, can you pull that microphone down towards you a little bit?
That's right.
That's okay. And do you want any rebuttal time?
I do want to reserve the maximum amount of time for rebuttal, so I'll intend to just briefly cover my...
You tell me what you want, how much you want to reserve, and he'll put it in the clock.
If I can get 10 minutes, I'd
There
like...
you go.
As court-appointed counsel for Mr. Heifner. Mr. Heifner was somewhere in Georgia for some purpose, and I've not been able to determine why, convicted of something that put him under the sex offender registry. While he was up here, and when I was appointed to him, he had stolen some property from, some money actually, from a convenience store here, pleaded guilty, and by arrangement with the state, was given 3 years probation. 2 years and 6 months later, he was brought in under the violation warrant, which is in the file, charged with violating the conditions of his probation. After hearing the case, the judge did find him guilty of violations. And finding him to be a threat to society, simply revoked his probation, leaving him with a 3-year sentence to serve, or the most part of it. The first issue I would bring before the court is the sufficiency of the warrant. This warrant was based upon an affidavit listed to as Ms. Fox, his probation officer, but not signed by her. Signed instead by another DOT or DOC operative that worked directly with the courts. I think it is clear that it is both legally and practically impossible for one person to swear to another. And it is our position that this lack of an affidavit rendered the warrant invalid, and we had moved that this be dismissed.
All right, that was my question, counsel. So even assuming there was some deficiency in the violation of probation warrant, why would the remedy be dismissal? I mean, what came out of the defendant being brought into court to face these allegations?
The problem would be, Your Honor, that if the warrant bringing him into court is invalid, then there's, in law, no prosecution.
Well, did any further evidence of probation violations come out of his being brought into court? Were additional violations stacked on to his charges?
No, Your Honor.
Okay. So where exactly are you gleaning that the whole case has to be dismissed? That's one thing I didn't understand.
The basis for prosecution under our Rule 3 and Rule 4 is the affidavit of complaint. If there is no affidavit of complaint, there is no valid warrant. And there can be no prosecution under an invalid warrant.
Okay. Do you disagree with the state that even though it was signed by another probation officer, that the warrant gave sufficient notice to your client of his violations?
I'm sorry.
Did the warrant give notice of his probation violations to the defendant?
In very general terms, yes, Your Honor.
Okay. Okay. And there was a hearing where he answered those allegations, correct?
He did not testify, Your Honor.
I'm sorry. Where the court considered those allegations?
Yes, Your Honor.
Okay. All right.
I would call the court's attention on this to the case of State versus Sandusky. In that case, and this was not a probation case, it was a summons, and the subject of the summons did not appear following the command of TCA 40-7-118, quote, "The court shall issue a bench warrant for the person's arrest." The court issued a bench warrant without specifically swearing to an affidavit of complaint. Officers took this warrant to the residence. It was at that no response was made to their knock, and the rear door was open. They entered and saw substantial marijuana production being conducted inside the house, at which point another person, the defendant in this case, Sandusky, appeared, said that he lived there, and told them to leave. They would not consent to a search. They went and got a search warrant, came back, saw the same thing, arrested him.
Aren't there a number of cases from this? Aren't there a number of cases from this court saying that the statute does not require a sworn affidavit as a prerequisite to issuing a probation violation warrant? What do we do with those?
There are a number of cases saying that, Your Honor, and none of them are reported. Therefore, you have to rely upon, they are persuasive, but what that means is, I believe, that you look at the reasoning behind it and see if it's satisfactory. But there's almost no reasoning. One case says that this phrase, critical phrase, as in any other criminal case, obviously talks about the service of the process. But service is covered in the next sentence, not in this one. Most of the other cases just cite that one. So the question is, what logic, what argument really has been presented that we could look to in those cases to inform our decision? The Supreme Court has long struggled with the problem of unreported cases. At one point, they just simply forbade it, placing the situation where there were two Tennessee laws, one in Tennessee courts and one in other courts, that were not so limited. And the solution there was to use the reasoning behind the unreported case and present it to the courts. And that, I believe, is what they mean in Rule 4. The other issue, if I might move on, has to do with the, has to do with the decision that he was a threat to society. The defendant was a threat to society. Now, at the hearing, the defense did not present any evidence. You can lay that on me. I've always been told that it's unwise to disprove something that hasn't been proven. There was evidence that he had, contrary to his obligations, utilized the internet. And it was that he was convicted of. But there was nothing in the proof as to the content of that use. And the state had had that phone for nearly 3 months. They could have presented proof if there had been any improper use of the internet or if it had been used for an improper purpose. The record is silent. I would submit that on a silent record, you cannot assume that a defendant has done something. Without that, there's no reason for the rather extreme penalty of letting him, after having served by this time 2 3/4 years of his sentence on probation, serve the entire 3-year sentence. And I would ask that that aspect, at least, of this decision be overturned, because I believe that is, by any manner of means, too extreme a penalty based upon the proof in this case, which is what must govern, or should govern, all judicial actions. Thank you, Your Honor.
Thank you, Counsel. You have the balance of your time for rebuttal.
I'm sorry?
You can have the balance of your time for your rebuttal.
Yes, Your Honor.
All right. General?
May it please the court, Ryan Davis on behalf of the state.
Pull that up just a little bit. Thank you.
This court should affirm the trial court's judgment because, for 2 reasons. Number one, the probation violation warrant was valid. And number two, regardless of whether the warrant was valid or not, the trial court properly exercised its discretion in ordering full revocation. Starting with the warrant issue, we know from this court's cases that probation violation warrants are different than arrest warrants, and everything's a lot more relaxed in the probation context, and so they're not governed by rules 3 and 4.
They're more relaxed, but the judge is saying in the warrant that someone swore this to me, and here we have someone telling someone who's telling the judge. I mean, there's relaxed, and then there's not completely accurate.
Yes, Your Honor. And so I think in this case what we have is a situation where the court liaison for Division 1 here in Knox County signs all the warrants. And so I guess it is hearsay in that sense, but it seems like it's reliable hearsay. And so the individual that signed the warrant knew of the allegations contained in the warrant. And I think Judge Sword mentioned that during his findings.
I guess, to the point, and Judge Ayers asked this question, and counsel pointed it out as well. I mean, we have these cases, but they're all unreported. And at the end of the day, the judge is issuing a warrant that allows law enforcement to take someone into custody. And he's doing it based on hearsay. And everyone's argument that this is okay is based on unreported cases. So, I mean, that, to me, that just kind of strikes me a little funny, is that if I have the right to infringe upon your liberty and take you into custody, it can't be because the courtroom clerk happens to know the probation officer, and the probation officer told the clerk, and the clerk told the judge, and the judge signed a warrant to restrain your liberty.
Yeah, sure. And I understand that. And when I first read the statute, I thought that was a little odd too. But on the cases front, they're all unreported, but it's an unbroken line of unreported cases dating back to 1985. And then we have cases from the early 2000s, the mid 2010s, the late 2010s. And we know from, just the concept of statutory stare decisis that the consistent interpretation of statutes over time is important. A panel of this court recently, I think, in State v. Morgan, it was an opinion by Judge Greenholtz, really explained well the doctrine of statutory stare decisis. And so I think those cases are extremely persuasive on one hand.
Let me ask you this, and I'll let you move on from this point, but counsel seems to suggest that it's really one case back in the 80s that said this, and everybody else just cites to it with no explanation.
I wouldn't read the cases that way, Your Honor. I think this court's analysis, generally panels of this court engage in thorough, reasoned analysis when they're citing cases, and so I don't necessarily.
Well, I'm not saying, but I'm just that they all will say that it's the same language, and they just cite to State versus Smith, and then the next court that has it goes, here's all this language, State versus Smith, now State versus Jones. Here's all the same language. And so no one's really, all these cases aren't really changing the analysis or looking at the analysis. They're just taking what's been said and just adding another cite to it. Would that be correct?
I wouldn't view it that way.
I'm not saying they're wrong.
Right.
I'm just saying, is that a correct way of looking at how this has unfolded over the years?
I think you could look at it that way,
Okay.
But we also know that the Chisholm case, the statute at issue there, the legislature changed the statute, and so right now we're under 4035 311 A1A, and it was a previous statute before. So the legislature changed the statute, and this court has continued on citing Chisholm, and the legislature is presumed to, the legislature is presumed to follow this court or understand this court's decisions, and so. Those cases are very persuasive, and if this court wants to offer clearer guidance in the form of a published opinion, that's within this court's right to eventually do, but we think those cases are on solid ground.
Right.
And also, regardless of the warrant, Your Honors, the defendant was brought into the courtroom for his probation revocation hearing, and Judge Wilson, to your point, the state presented its allegations. The defendant had notice of the allegations that were right there in the warrant, and the defendant's actual probation officer, Miss Fox, she testified to the violation, and then Judge Sword made good findings. He covered the violation determination and the consequence determination.
Judge Sword made the finding that this individual was a danger to the community. Based on what? Deceit
Or hiding his social media accounts. So this defendant, he was on probation for theft, but he was also a sex offender. And so as part of his probation, he had to comply with the sex offender registration requirements. And he was instructed, you're not allowed to have a phone. And he got a phone. Then that phone was seized. Then he got another phone, and he opened these social media accounts.
I get that, but how does the fact that he lied make him a danger to the community? I mean, counsel pointed out, and it was my thought when I read the briefs, what's on the social media accounts, what's in the phone that makes someone go, whew, this person's a danger to society versus, this guy's a liar and he's good at getting phones. There is a difference between being a danger to society, in my opinion, and just having lied to your probation officer.
Well, it wasn't just that he lied. He actively hid these accounts for an extended period of time. And that is a significant fact. That is deceit. And given that the defendant is a sex offender and he's opening these social media accounts that lots of kids use, it makes sense
But is there any proof? Was there any proof at the hearing on what accounts they were, how they were used, who had access?
I think there was some proof on they were Instagram, Snapchat, maybe TikTok. So the social media platforms themselves. I don't think there was any proof of, what was defendant looking at or anything like that, or
Right,
was he?
so that's my question. I mean, what if the defendant had put on proof, well, Your Honor, if you look, everything he did on any social media platform was how he's reformed his life. He's a born-again Christian. All he does is look at Christian sites. All he does is look at cooking sites. I don't care what it is, but it has nothing to do with what he's charged with, right? It's all we would call innocent scrolling of social media. Is he still a danger to society then?
I think the court would consider the proof that the defendant would have put on in that situation. Here, the defendant chose not to put on any proof, and given that we're in an abuse of discretion framework, given the thoroughness of the findings, I would say that Judge Sword's findings are reasonable, and especially given that we have this long period of deceit, this long period of lying, and I think—
How long of a period?
I think it was about 3 months. And if we go back, when defendant had his phone seized the first time, the reason that Mrs. Fox found out about that was because she got a report that the defendant was engaging in threatening behavior. And so really, that's what's kicking off this entire episode. And just viewed in that context, Judge Sword made a reasonable decision here to find that the defendant was a danger to the community.
But there's no proof to support that other than again, another hearsay statement, she heard that he was engaging in abusive. There's no proof that that was actually part of the social media, right?
No, I don't think so, Your Honor. And so I understand the court's, hesitance about—
The violation's clear. I want you to understand. I mean, we understand that the state seems to have proven, obviously the record will bear out, that there's a violation. The question is what the trial court relied on as far as full revocation versus placing him back on probation.
Yes, Your Honor. And I think really, so the court's, in the record, the court's findings on the violation determination are really on page 2021 on volume 1, and the court really does hang its hat on the deceit, the hiding, and then the court makes what I would call a reasonable inference that you have these social media accounts and they are used by lots of children, and that combined with the deceit and the hiding, that's an issue. And like I said, because we are in the abuse of discretion, standard of review here, I think that's a reasonable determination. Pending any further questions, we ask that you affirm. Thank you.
Thank you. Mr. Crane, I think you have 8 minutes left.
Thank you, Your Honor. The difference that is postulated between violation of probation warrants and other warrants, I cannot find that anywhere in the Tennessee Code. I can't actually find it anywhere in the decisions of courts of Tennessee. Even those relied on, in this case, by the state in this case, the only one that gives anything, as I said, well, this obviously refers to service of the warrant. The as in other cases. It's not so obvious when you look at the statute. Because you've got the issuance of the warrant, and in the next section, you've got service of the warrant, and can be by, there is some apparently increase in the types of people, I'm sorry, I'm getting away from the microphone here,
All right.
that can serve it. And that's where your service comes in. As in other cases, is located with the issuance of the warrant. And what can it mean except in other criminal cases? Now, the question of reliable hearsay, rules of criminal procedure set out a provision for hearsay on the affidavit of complaint. But you have to say who the hearsay originated from and why it is reliable in order for the magistrate to make a determination that probable cause has been shown. That's not done here. Regarding the question of proof of being a threat to society, the only thing in this record that could support that is the fact that he's on the sexual offenders list. And that comes very close to making that a bill of attainder, a status crime. Now, I think it's also pertinent to consider that if he were to be released from probation and his sentence, having served nearly very close to a year, he would not be released in the normal sense of the word. He was on the sexual offender registry when he got these charges. He will be on it after they are resolved. And he will still be subject to reporting as before. Your Honor, next month will contain the 50th anniversary of my admittance before the Supreme Court of Tennessee. I flatter myself that in those 50 years I've learned a few things about law and justice. Your Honor, it offends my sense of due process that a person can be hauled before a court in peril of losing something of his life, liberty, property, status, without a sworn statement as to why he should lose them. That is not the due process that I have learned. And I ask this court to provide him with that process. Thank you, Your Honors.
Thank you, sir. Call the next case, please.